Good day. My name is Kenechukwu Igwenagu. I am a virtual intern at HARLEMSolicitors and a law student of Enugu State, University of Science and Technology, ESUT. Within the next few minutes, I'll be talking about the National Telecommunications Regulatory Environment. I'll be particular about the provisions of the law establishing the national regulator vis-a-vis service providers and the consumers of telecommunication services. In the course of my discussion, I'll be analyzing the following laws: the Nigerian Communications Act, the National Environmental Standards for Telecommunications and Broadcasting Facilities Regulation 2011, and the Law of Torts. I shall consider them accordingly. Number 1. The Nigerian Communications Act. This act was signed into law by the then President, Olusegun Obasanjo, on the 8th of July 2003, after being passed by both houses of the National Assembly. This act created the Nigerian Communications Commission, the NCC, as an independent, impartial, and regulatory body to be saddled with the responsibility of overseeing the affairs of the telecommunications industry in Nigeria, and to be headed by an executive vice chairman. One major objective of the NCC is to promote the implementation of national communications and telecommunications policy, whilst ensuring free and fair competition. With regards to the regulatory powers of the NCC published the legal guidelines and technical specifications for the installation of telecom masts and towers, subsequently referred to as the 2009 guidelines. The 2009 guidelines provide that the maximum height of a telecom mast or tower should not exceed 150 meters. However, to exceed this requirement, a written approval must be granted by the NCC, and it must be certified and confirmed that such height is not detrimental to public health or safety, does not contravene any written law in force at that time, or does not infringe on the right of an individual or any other telecom service provider. The Nigerian Communications Act of 2003 also provides that no person shall operate any communication system or facility, nor provide any communication service unless authorized under a communications license or exempted under regulations made by the NCC subject to the Act. A license is a legal document that grants the licensee the sole authority to carry out a given telecommunications operation. Generally speaking, the NCC establishes two types of license: the individual license and a class license. The individual license is a license that is granted to a specific person to carry out a given telecommunications operation, while a class license is a license of general authorization in which terms and conditions are common to all license holders. Failure to obtain a communications license or failure to obtain an exemption under regulations issued by the NCC subject to the Act is an offense and attracts punishment. Such an individual will be liable in conviction for a fine not less than the initial fee of the relevant license, or not exceeding 10 times the initial fee of that relevant license, or an imprisonment term not exceeding 1 year, or both imprisonment and a fine. The Nigerian Communications Act of 2003 also discourages the infliction of detriment and inconvenience on individuals and the environment, and therefore places statutory obligations on telecom service providers to exercise due care in the installation of telecom masts and towers. This is provided under Section 136 Sub 1 of the NCA 2003. This provision is further strengthened by Section 136 Sub 2, which emphasizes on environmental remedial obligation and ensures that the owners of lands do not suffer damages as a result of misuse of their lands, and places obligations on telecom service providers to restore the lands to the initial positions before the installation of such telecom mast or tower. Having said all this, it should be noted that telecom matters remain the sole prerogative of the NCC, subject to Section 3 Sub 1 of the NCA 2003 via the 1999 Constitution. Number 2, the National Environmental Standards for Telecommunications and Broadcasting Facilities, Regulation 2011. This regulation was enacted in NESRA's bid to carry out its duties in the protection of the environment. The main thrust of this regulation is to enforce environmental standards, promote public health care and safety, and minimize the losses incurred during telecommunications operations. While the 2009 guidelines prescribe a minimum setback of 5 meters, the NESRA's Regulation 2011 require a minimum setback of 10 meters. Now, this was a battle of superiority between NESRA and the NCC guidelines. Now, the question is, how was it resolved? It was resolved after the FState saga, where the two ministers of the supervisory ministries met and agreed that the minimum setback should be 7.5 meters when 10 meters was impossible. The NESRA's Regulation 2011 also emphasizes on environmental remedial obligation and ensures that the siting of telecom masts and towers is not detrimental or are not detrimental to individuals and the environment. This is subject to Section 5 Sub 2 Paragraph A of the Regulation 2011. Failure to comply with this requirement is an offense and attracts punishment. Such an individual will be liable in conviction for a fine not exceeding 5 million naira or an imprisonment term not exceeding 5 years, with an additional fine of 50,000 naira for every day the offense persists. This is subject to Section 11 Sub 2 of the regulations. Just like the NCC, the NESRA's Regulation 2011 provides for the abandonment of towers. A tower is deemed to be abandoned if it has not been used for a minimum period of 3 years. This would lead to the dismantling of such telecom mast or tower by the NESRA in compliance with the Environmental Impact Assessment Act 2004 and the NESRA Establishment Act 2007. And a 6-month period will be given to the telecom service provider to restore the land to the initial position before the installation of such telecom mast or tower. Finally, the law of torts. The thorny nexus between Nigerian telecommunications and the law of torts can be seen in the provisions of the Constitution on fundamental human rights. On one hand, there is a constitutional guarantee for an individual's right to freedom of expression, freedom to hold opinions, freedom to impact and receive ideas without interference. On another hand, there is a constitutional guarantee on the right to privacy, privacy of individuals, privacy of telephone and telegraphic conversations. It is quite sad that the NCA 2003 is silent on the role of the NCC to deal with privacy issues under communications. However, sometimes this can be implied from its functions. Thus, with the constitutional guarantee on the right to privacy, an aggrieved individual, through the agency of the court and the machinery of the torts law, can regulate or control the affairs of a telecommunications operation or company vis-a-vis the enforcement and protection of the right to privacy. Thank you.